Punarac, what you just said probably indicates that you are not clear about the legal implications of the charge preferred by the prosecution. Now, the prosecution is claiming that you committed rapes and or failed to stop raping being committed by your subordinates, and in this way you have perpetrated a crime against humanity. Now, what is meant by a crime against humanity? I'm sure that your legal counsel has already explained everything. You are aware of that. That means a serious attack on human dignity, very serious attack on human dignity, which may take the form of murder, rape, enslavement, extermination, and so on, in this case the former rape, which has as a target civilians, so committed not against soldiers but against civilians. This is the second legal ingredient, so very serious attack on human dignity in the form which I have just set out. Then having as a target as one or more civilians, and third legal ingredient of this offense is that this serious attack on human dignity is part of a widespread or systematic practice in the area or in the country where the offense has allegedly been committed. So therefore, this particular offense, in this case rape, has been classified by the prosecution as a crime against humanity. And you pleaded guilty to this count, crime against humanity, rape as a crime against humanity. I understand, but you may clarify this position, your position, that you don't feel that you are guilty of rape as a form of torture. Because one of the other counts is that what you committed must be regarded or classified, legally classified, as a form of torture. Is it clear to you what is meant by crime against humanity? Now, as you know, we have under our statute we deal with various classes of offenses: genocide, crimes against humanity, war crimes, grave breaches. Now, a crime against humanity, as has been held by a trial chamber, is an offense which is more serious, or may be regarded as more serious, as a war crime. You are pleading guilty to a serious offense, namely a crime against humanity. Are you aware of this legal issues, various legal issues which I have tried to explain to you? Are you aware of the implications?
Svestan sam sada sam svestan težine, u stvari šta znači zločin protiv čovječnosti u smislu silovanja. I ja kada sam se izjasnio taj dan, apsolutno nisam se izjasnio da sam organizovano, da sam po ubjeđenjima tim koji ste mi naveli, genocidnim, protjerivanjem bilo kako, da sam počinio takav čin silovanja. I ja moram uz objašnjenje da vam kažem da sam bio u zabludi u momentu kad sam rekao. Ja jedino što nisam htio dovesti sebe u zabludu, da slažem bilo kog momenta, pre svega sebe. Nisam počinio zločin protiv čovječnosti silovanja, ali sam počinio jedno djelo, jednu tačku iz ove optužnice, tačku u kojoj određena osoba navodi jednu radnju koju sam ja počinio, i ta tačka, optužnica je sročena, za mene nejasno, ne znam pravno kome je jasna, ali jednostavno ja imam 4 tačke u optužnici u kojoj kaže na vrhu gore da sam ja počinio protiv tih i tih svjedoka navodna djela, gdje stoji onda tačke 9.3, 9.4, 9 šta ja znam po redu, i onda dole ispod toga stoji 41, tačka ta i ta po tome. Ne stoji po kojoj tački iz cijele optužnice stoji to djelo. Ja sam kriv za tačku 9.10. Iz jednog dijela te tačke 9.10. I shvatite me da ja ne vidim u kojoj je tački 9.10 ta tačka se nalazi u kvalifikaciji same izjašnjavanja. Dakle, da je stajalo u šta ja znam, tački 41. Osjećam se krivim ili stavlja mi se na teret djelo zločina protiv čovječnosti po tačci 9.3, 9.5, 9.7, ja bi tada tačno znao da se izjasnim jeste za ovo sam kriv ili ne. Nadam se da sam uspio da objasnim svoju zabludu nepoznavajući pravo. Ja svojim braniocima, ja jesam cijelo vrijeme govorio i govorim i sad i uvijek, da neću ni jednog momenta dođem u situaciju da slažem. Ja sam došao ovdje svjesno, časno, pošteno, da vam kažem šta je istina, gdje sam ja u svemu tome i na vama je da vi kažete koliko sam ja kriv, ako sam kriv i da pošteno završimo sve ovo. Nadam se da me shvatate. Zašto sam rekao da sam kriv, a evo vi pokušajte da mi kažete u kojoj tački od te 4 se nalazi tačka 9.10. Je li to nek ulazi javna tužba? Nek mi kaže tačka 9.10 je sastavljena u tačku 41, 2, 3 ili 4. I po toj tački ja ću da se izjasnim da sam kriv. Pod određenim okolnostima koji se desio taj slučaj. A za ostale tačke, apsolutno se ne osjećam krivim i nisam kriv po cijeloj optužnici. Nadam se da se uspjevam pojasnim, da kažem, svoju zabludu i mogućnost koliko sam imao manevar u izjašnjavanju. Ja sam zato i rekao za tu tačku 41. Osjećam se krivim. Dakle, kriv sam. A za sve ostale 3 sam rekao nisam kriv. Decidno, jasno i čisto. Ne znam da li sam pravno povrijedio poslovnik ili pravilnik ili bilo šta. Ali moja želja nije bila da stvaram bilo kakve probleme, nego da jasno i pošteno kažem zašto sam kriv. Javna tužba je jutros imao sam priliku da joj pojasnim. Ukoliko nije shvatila moju poruku, ukoliko ne vjeruje u tu poruku, ja sam spreman da onda za kompletnu optužnicu ovakvu kakva stoji, po sve 4 tačke, izjasnim se da nisam kriv i da po čitavoj optužnici idemo u proces već kako ide, ako se izjasnim da nisam kriv. To je moj branilac, ako nek mi pomogne pravno, ako misli da ima nekih nejasnoća koje ja ne mogu da vam objasnim.
I now turn to the defense counsel, the prosecution. If I understood the accused correctly, he means to say that he is ready to repeat his guilty plea to count 41, crime against humanity, only with reference to the facts set out in paragraph 910 of the indictment. Is this? Yes, please, Mr. Pantelic. Is this
correct?
Your
Honor, let me be very precise. We've got enough time yesterday for conference. This morning, especially with presence of the prosecutor office, and these conferences were very, very important for Mr. Kunarac. Unfortunately, we cannot expect here that every client is, especially in this first period of appearance, is fully aware. Maybe after 6 months, 1 year, year and a half, he will be more familiar with all these grants, and because the role of defense is here. So I would ask Mr. Kunarac to explain you if it was clearly explained to him the difference between the crime against humanity, which is, as you stressed, most serious crime, and, for example, the grave breaches of Geneva Conventions or some other forms where we theoretically and hypothetically might find a place for his actions. So I explained him in various way all these things, and my guess is, my conclusion is that having in mind, all these details, he is not pleaded guilty under the count 41 crimes against humanity related to rapes. He expressed his willingness very, very precisely this morning to the prosecutor office also. So my conclusion is not that he pleaded guilty with all this explanation now for crime against humanity. what I understood from his statements, he said that he committed some crimes, but are these crimes fully related with some qualification in the indictment, or maybe it will be amended in further period? Let's see. So up to now, my guess is that my client is fully aware about these differences, and that he cannot consider himself guilty for particular count 41, crimes against humanity.
Mr. Pantelic,
Not to mention sub-rule 3E that we have to discuss more after.
Mr. Pantelic, do you want to say, do you intend to say that now your client is aware of, more aware of the differences between the various crimes, offenses provided for in our statute, and that he does not know whether he should plead guilty to, say, crime against humanity or war crime or a grave breach of the Geneva Conventions? However, he admits to committing the offenses which are set out in paragraph 9.10 of the indictment, because he made reference before to the facts listed there.
Yes, Your Honor, but if these factual grounds mentioned in paragraphs 9.10, 9.21, let's say, and 10.1, which he mentioned this morning in this interview, are related to crime against humanity, his position is that he is not guilty.
Yes.
But on the contrary, if this description of these actions are related to, for example, some form of grave breaches or customs of law or war, maybe in that case we can discuss another light of his possible plead guilty. That is the main issue. I mean, now if we are facing all these factual grounds and qualifications, my guess is, and that was my advice to him finally, not to plead guilty under these circumstances, because as you well know, we have to have some basic and important elements of one crime. You very, very precise explained to my clients and to the audience these differences, and he is well aware about it, especially because of the third element of this crime.
Namely, that the offense must be part of
widespread
or systematic practice.
That's right. And I asked him very precisely, Mr. Kunarac, do you aware, or can you explain us this general atmosphere, and do you consider this atmosphere as a widespread situation of torture, of massive terror, etc.? And do you personally, have you been a part of all these actions, hypothetically? And he said no. So I cannot say that that's a crime against humanity under these circumstances. Yeah.
But as I say, regardless of the legal classification of the offense, war crime, crime against humanity, grave breach, is it correct? Am I correct in saying that Mr. Kunarac admits to the commission of the facts listed in paragraph 9.10 of the indictment? This is a point of fact, whether or not, leaving aside the legal characterization of the offense.
That is right, Your Honor.
He is admitting that. All right. I wonder whether the prosecution can state a position.
Your Honor, if it would have been about legal problems only, we wouldn't have had any problems, and we would have been very flexible and would have been willing to do any possible amendment on short notice. But that's not what it is about. It's about the factual basis, and even about the factual basis of this count 9.10. In 9.10, it's clearly stated that 2 women were taken to this headquarters One was raped brutally, gang raped brutally, and one was personally raped by this accused. But according to what he's told us, he hardly committed any offense at all, because what he described wasn't that what he has said in the indictment. Not at all.
Well, in the light of what has just been said, it is clear to the court that we have to enter a not guilty plea and set a date for the status conference. However, before we adjourn, let me point out that this awkward situation has been created by the fact that the accused has not been duly instructed, has not been duly advised by the legal counsel. Normally, before entering a guilty plea or not guilty plea, the accused should be advised by defense counsel, who should explain to him or to her the difference between the various offenses which are listed in our statute and which are charged in the indictment. If he had been well advised, probably we would not have been put in this rather awkward position. I wonder whether since you said that you would like to make some explanation in camera, in a closed session, I wonder whether we could adjourn now, and we could even, would you be in a position to hold the status conference, maybe in half an hour? We move on to a closed session, you give us some confidential information, and then we discuss various matters within the framework of a status conference. Thank you. So is it all right with half an hour, or is it too much or too little? Half an hour? My colleague, 20 minutes. 20 minutes. So we adjourn, we stand adjourned. 20 minutes.
All rise, veuillez vous lever.